Tips for completing the SPDS for environmental issues. Be honest. Sellers must disclose all known issues to avoid future legal consequences. Even if a problem was fixed, it should still be disclosed. Provide details. For any yes responses, give as much detail as possible in the provided space. If applicable, include dates of remediation, the companies or contractors involved, and the outcomes. Consult professionals. If the seller is unsure about certain environmental issues, such as asbestos, radon, or mold, it's wise to consult a licensed professional for testing and advice. Notice to seller and buyer. The Arizona Department of Environmental Quality requires a pre-transfer inspection of on-site wastewater treatment facilities on resale properties. This section of the Arizona Seller's Property Disclosure Statement, SPDS, is titled Environmental Information and is designed to uncover any known environmental conditions or external factors that may affect the property's value, safety, or livability. Let's break it down line by line. Environmental issues on the property. Question: are you aware of any past or present issues or problems with any of the following on the property? You're asked to check yes or no and then mark which issues apply from this list. Soil settlement expansion. Has the soil shifted or expanded, which could impact foundations? Drainage, chalk grade. Are there problems with how water drains, or is the land graded poorly? Erosion. Has the land been worn away by water or wind? Fissures. Are there visible or known cracks in the earth, common in parts of Arizona? Dampness, moisture. Are there persistent moisture problems, such as in basements, walls, or crawl spaces? Any other relevant environmental conditions not listed above. What to do? If the seller is aware of any of these problems on the property itself, now or in the past, check yes and specify which issues apply. Explain in the space below when it started, where it's located, what has been done about it, if anything, etc. Environmental issues nearby. Question: are you aware of any past or present issues or problems in close proximity to the property related to any of the following? This is asking if nearby areas, not necessarily your property, have experienced soil settlement, expansion, drainage, grade erosion fissures, any environmental geologic conditions that could affect property value or safety. What to do? If the seller knows of nearby fissures, erosion-prone land, or drainage problems that could impact the property, check yes and explain. Note to buyer: there's a reference to earth fissure maps available from the Arizona Department of Real Estate. These maps show where underground cracks or splits have been documented, useful for buyers in Arizona's high-risk fissure zones. Nuisance or environmental effects. Question: are you aware if the property is subject to any present or proposed effects of any of the following? Check if the property is or may be affected by airport noise, traffic noise, rail line noise, neighborhood noise, landfill, toxic waste disposal, odors, nuisances, sand, gravel operations, factories, shooting ranges, etc. What to do? If the seller hears aircraft overhead, smells landfill odors, or has trucks from a quarry rolling by daily, that must be disclosed. Also applies to proposed developments, not just current ones. If a new rail line is being planned, for example. Clandestine drug lab. Question: are you aware if any portion of the property has ever been used as a clandestine drug laboratory? Refers to meth labs or other illegal drug manufacturing, storage on site. Arizona law requires disclosure if the property was used for this purpose. Even if it was cleaned up, it must be disclosed due to potential health and safety risks from chemical contamination. What to do? Check yes if known and provide a brief explanation, including any cleanup or law enforcement involvement. Nearby airport. Question: Are you aware if the property is located in the vicinity of a public or private airport? This is separate from noise. It's about proximity to flight paths or airport zones. What to do? If the property is near an airport or under a flight path, check yes and describe. Military airport vicinity. Notice to seller and buyer. Arizona law requires that if a property is located near a military airport or ancillary military facility, the seller must disclose this in writing. The State Land Department prepares maps showing these zones, and a notice is also recorded in public records. Question: is the property located in the vicinity of a military airport or ancillary military facility? What the seller must do. If the property is near a military base, e.g., Luke Air Force Base, check yes and explain. Example explanation. Property is located 4 miles from Luke AFB and occasionally experiences flyover noise. Hazardous substances or conditions on the property. Question: are you aware of the presence of any of the following on the property, past or present? Hazards include asbestos radon gas, lead-based paint, especially relevant for homes built before 1978, pesticides, underground storage tanks, like old heating oil tanks, fuel, chemical storage. What the seller must do. Check all that apply if known. Explain what was found, when, how it was handled, or if it's still present. Example: lead-based paint disclosed and tested during purchase in 2010, abatement completed by certified contractor. Regulatory environmental zones. Question: are you aware if the property is located within or subject to any of the following ordinances? Includes Superfund, WCARF, CERCLA. These are environmental cleanup sites where hazardous waste contamination is regulated by federal or state law. Wetlands area, if the land includes or borders federally protected wetlands. Natural area. Open spaces, land designated to remain undeveloped for environmental reasons. What the seller must do. Check all that apply. If yes, briefly describe what applies. Example: BQARF registry site located 2 miles east of the property, no known direct impact. Mines or abandoned wells. Question: are you aware of any open mine shafts, tunnels, or abandoned wells on the property? What the seller must do. If yes, describe their exact location on the property. Example: abandoned hand-dug well located in the northeast corner of the backyard, sealed and capped in 2005. Floodplain or flood history. Question 1. Are you aware if any portion of the property is in a floodplain way? Question 2. Are you aware of any portion of the property ever having been flooded? What the seller must do. If the property is within a FEMA-designated flood zone, or if it has ever experienced flooding, even from heavy rain, this must be disclosed. Explain where and when, and include any mitigation efforts, like drainage improvements or French drains. Water leaks or damage. Question: are you aware of any water damage or water leaks of any kind on the property? What the seller must do. Disclose leaks in roofing, plumbing, appliances, walls, or floors, even if they were repaired. Explain what occurred and how it was handled. Mold issues. Question: are you aware of any past or present mold growth on the property? What the seller must do. If yes, describe the location, cause, e.g., water leak, and remediation efforts, if any. Flood insurance notice to buyer. This long notice informs the buyer about changes in flood insurance laws. Mortgage lenders may require flood insurance if the home is in a flood zone. Due to federal law, Biggert Waters Act, and HFIAA, flood insurance premiums may increase significantly. The buyer should not rely on the seller's current flood insurance premium. It might be much higher for the new owner. Buyers are encouraged to shop around for flood insurance quotes, talk to FEMA or insurers about potential costs. Understand whether the seller's policy can be assumed. Other. This is a catch-all at the bottom. to specify if there's any other environmental condition the seller is aware of that hasn't already been addressed. It should go here. On the Attention Buyer cover page of the residential purchase contract, the buyer is informed about inspections they should seek out if it is a material matter to them, or the inspection reveals a possibility of issues that the inspector is not qualified to inspect. Mold and environmental addenda are supplemental disclosures or agreements that go beyond the basic seller's property disclosure statement, SPDS. They help real estate professionals, buyers and sellers more clearly document and communicate environmental risks, especially concerning mold, asbestos, radon, lead paint, and other hazards. Some brokers have their own mold addendum that may be required for the transaction file. Here are the key benefits of using these addenda. 1. Risk reduction for sellers. Protects the seller from future liability by clearly disclosing known environmental issues or affirming the absence of them. Shows that the seller is acting in good faith and complying with disclosure laws. 2. Informed decision-making for buyers. Helps buyers understand potential health hazards, remediation needs, or costs they may face. Allows buyers to make an educated decision, especially if someone in the household is sensitive to mold, radon, etc. 3. Documentation of hazards and remediation records. The existence of environmental issues and what was done to resolve them, e.g., mold remediation, radon mitigation systems. Provides a paper trail in case questions arise during appraisal, insurance, or lending. 4. Helps in obtaining financing and insurance lenders, and insurers often want assurance that the property is safe and insurable. A mold environmental addendum can show that known issues were disclosed and addressed, making the underwriting process smoother. 5. Reduces deal fallout. If environmental concerns come up during inspection and there's no documentation, it can delay or kill the deal. These addenda get ahead of surprises, keeping the transaction on track. 6. Promotes compliance with federal and state laws. Some issues, like lead-based paint in homes built before 1978, are subject to federal disclosure requirements. Addenda help ensure compliance with EPA, HUD, state, or local regulations. 7. Adds clarity and peace of mind. Buyers feel more confident when sellers provide detailed information. Sellers and agents reduce their risk of post-closing disputes or lawsuits. Disputes over mold detection after closing can be tricky, but here's how they're typically handled, depending on the circumstances and disclosure laws in your state, like Arizona. Was the mold pre-existing and known? If the seller knew about the mold, or conditions conducive to mold, like leaks or water damage, and failed to disclose it, this could be considered fraudulent non-disclosure or misrepresentation. In that case, the buyer may file a legal claim against the seller or agent for failing to disclose known material defects, seek damages for the cost of remediation, repair, or even rescind the sale in severe cases. Use mediation, arbitration, or small claims court, depending on the purchase agreement terms. Key factor: the buyer must usually prove that the seller knew and intentionally concealed the mold issue. Was there an as-is sale or mold addendum? Many properties are sold as-is with the understanding that the buyer is responsible for inspections. If the buyer waived inspections, or an inspection failed to detect mold, or a mold environmental addendum disclosed risks that the buyer accepted, it can be harder to hold the seller accountable after closing. However, as-is does not protect against intentional non-disclosure. Did the buyer conduct an inspection? If a home inspection or mold inspection was conducted and missed the mold, the buyer might have recourse against the home inspector for negligence, be limited to any remedies outlined in the inspection contract. Dispute resolution. Methods. Most Arizona real estate purchase contracts, like the AAR Residential Resale Real Estate Purchase Contract, include a dispute resolution clause. This usually requires mediation first, non-binding, then possibly binding arbitration or court if mediation fails. What buyers can do if mold is found. After closing review, the SPDS and inspection reports to compare what was disclosed versus what was found. Get a professional mold assessment and remediation estimate. Speak with a real estate attorney, especially if there's evidence of concealment. Contact the seller, often required before filing a lawsuit under AZ law. Proactive tips for buyers and sellers. Buyers should always get a mold inspection if there's any history of moisture, leaks, or musty smells. Ask specific questions during due diligence. Request past remediation reports if available. Sellers should disclose all known mold issues and water damage, even if remediated. Keep documentation of repairs and mold treatments. There have been many court cases involving mold, especially around non-disclosure, health issues, property damage, and duty of care in real estate transactions. Here are a few notable ones, including some from Arizona and national examples that highlight common themes. Martinez versus Woodmar 4. Condominiums, Homeowners Assen, Incants, Arizona. Court, Arizona Court of Appeals, 2009. Issue: a tenant sued the HOA over toxic mold exposure in her unit, alleging negligence in maintenance and failure to act. Outcome: the court held that the HOA had a duty of care and that its failure to maintain common areas could lead to liability. Takeaway: HOAs can be held liable if common area issues, like leaks, lead to mold-affecting units. Ballard vs. Fire Insurance Exchange, Texas Court, Texas, 2001. Issue: a homeowner sued her insurer after a leaking pipe led to mold, and the insurance company denied full coverage. Outcome: jury awarded $32 million in damages, later reduced, finding that the insurer acted in bad faith. Takeaway: insurers may face severe consequences for failing to fairly investigate or cover mold-related claims. Allison v. Shell Oil Co. Mats, Louisiana. Issue: tenants sued for health issues caused by toxic mold, claiming the landlord failed to maintain safe conditions. Outcome: tenants won damages for medical expenses and mental distress. Takeaway: landlords may be liable for health damages due to mold if they fail to act on known problems. Guzman versus John Pro Cleaning Systems. Issue: the janitor claimed workplace exposure to mold caused respiratory illness. Outcome: employer was held liable for unsafe working conditions. Takeaway: mold in commercial settings can lead to workers' comp or personal injury lawsuits. Arizona Real Estate Commission. Disciplinary cases. While not always in court, there are Arizona Department of Real Estate, ADRI, disciplinary actions, where agents failed to disclose known mold or water damage, did not properly investigate red flags, e.g., musty smells, visible staining, or gave false assurances to buyers. Penalties include fines, suspensions, and license revocation. Legal themes in mold cases: non-disclosure of material facts, especially in SPDS, failure to remediate known issues, negligent inspections or repairs, breach of warranty or landlord duties, bad faith by insurance carriers, injury or illness caused by mold exposure. If a real estate agent knows about mold in a property but fails to disclose it to their buyer, the consequences can be serious, both legally and professionally. Here's what can happen. Violation of fiduciary duty. Agents owe buyers the duties of honesty, loyalty, full disclosure, and reasonable care. Non-disclosure of mold, ansau, breach of fiduciary duty. Even if the seller didn't disclose it, the agent must disclose material facts they are aware of. The buyer may sue the agent directly for damages caused by the mold, repair costs, medical issues, loss of value, etc. Realtor R. Code of Ethics violation. If the agent is a realtor R. member of NAR, then hiding known mold issues could violate. Article 2. Avoid concealment of pertinent facts. Article 12. Present a true picture in all representations. Penalties may include fines, ethics training, suspension or termination of realtor R membership. Arizona Department of Real Estate, ADRE. Sanctions. ADRA can investigate and discipline agents for unprofessional conduct, misrepresentation, or failure to disclose material facts. Possible outcomes: civil penalties, fines, license suspension or revocation. Public record of discipline, hurts reputation. Civil lawsuit from buyer. The buyer could sue for fraud or negligent misrepresentation, breach of contract if disclosure forms were incomplete or misleading, cost of mold remediation, repairs, and medical expenses. Sometimes, there are even punitive damages if the concealment was willful. Key case law, Arizona context. In Martinez v. Woodmar 4 HOA and others like it, the courts have held that the duty to disclose known defects extends to mold and similar environmental hazards. Agent best practices. Always err on the side of disclosure. If you smell mold or see staining damage, advise further inspection even if the seller says it's been taken care of. Use the SPDS and mold addenda to protect both parties. Document what you observed, what you disclosed, and any buyer instructions in writing.